Has everybody got their mics on? All right, let's call this meeting to order. All right. Will the board please look over the minutes and see if there's anything that they would like to change or comment on?
Not me.
Anybody like to make a motion to approve?
Make the motion that we approve.
Second.
You got all that, sir? All right. All in favor, say aye.
Aye.
Any opposed? All right, minutes passed. Go ahead. Charlie, you need 2 copies or just 1?
2, please.
2, okay.
Vice Chair, as you work through this process, understanding that there may be some questions related to tonight's conditional use permit, it may be advisable to move that to the front of the line, and at least answer the question of applicability of this board,
Okay.
so that we don't have to hang out. There are no other applicants here as well. There are no other applicants there. This is fine. It's been a very interesting day.
Not necessarily.
I appreciate
I
that.
think it's getting to be more often they are just turned down, but no, we've approved something.
It says they're supposed to show up.
I mean, well, they should. If it's simple enough, you know,
Thank you.
You're welcome.
as opposed to, let's look in, let's investigate, see what's here. But if there's any
I think
real
this is the
questions,
one they
let me
They
know.
talking about 22? Okay. All right.
You have me to swear in some witnesses?
Yeah, I was going to find out. Does anybody wish to speak tonight? If you do, please sign in if you haven't already done that. If you've already signed in, just go ahead and swear in,
Yes.
Charlie.
Please stand, raise your right hand, and do you swear or affirm the statement you make tonight to be the truth to the best of your information and belief? Thank you.
All right, with that, we'll move on to this new application.
We're going to ask a question, and then we'll proceed from there.
Okay, so at the pleasure of the board, I'd like to discuss the applicability of the conditional use permit for the, jump ahead here, for case G 2025-22. Specifically, this is an application for a conditional use permit for a non-retail commercial use for a medical office. And this situation, in discussion with board counsel, there may be an opportunity to allow this use by right, depending on this board's interpretation of what is retail sales. To be quick about this, in the interest of everybody's times, this property is zoned B2. Within the B2 zone, retail stores are listed as an allowed use, allowed by right. The definition of retail stores isn't included in our definition section. The closest we have is retail sell, and that reads as thus: the sale of any product or merchandise to the customer for their own personal use, not for resale. The reason staff initially requested a conditional use permit is because that definition lacks a service component associated with it. Obviously, a medical office primarily offers services, not product or merchandise. With that said, though, this is a service that's being offered directly to the final consumer. There are lots of other medical clinics and similar uses in the B2 zone that pre-exist. However, several months ago, a similar use was brought forward in the same zone, and we went through the conditional use permit process. And so we believe that it fits the category, if not the strict definition, of non-retail commercial. But this seems apparent that it may be an incongruency within the code. And if it's the board's wish, this could be considered a by right use, and you have the ability to make that determination, in which case a conditional use permit is not required, and we could refund these people their money. If you believe that there is a benefit to going through the conditional use permit process, staff has prepared an entire presentation related to it with potential conditions. Ultimately, we are recommending approval of the use. Yeah. So either way, staff is in support of this use, whether through a use by right or a conditional use permit. Questions?
You have
Mr.
one that's condition, you have a previous conditional use, but you also have some that are by right? So you have a consistency issue?
So right now, if you had asked me 35 minutes ago, if this use was a use by right in the zone, I would say no, because we lack that service component in the definition of retail sales. And so anytime, if there was this applicant or any other applicant moving forward had called us and said, we want a medical office in the B2 zone, we would have recommended a conditional use permit process. In consultation with our attorney, and again at the discretion of this board, if you believe that medical services like the applicant is proposing is in fact retail, then we would move forward advising that that is allowed use by right and would not need a conditional use permit. Within the code, basically, in questions of applicability of zoning regulations, the Board of Adjustment is the final arbiter. And so we'd be going based on what this board wishes to do with this particular use.
So if the board wants to go with by right, will that also involve a change in the definition that you've been looking at?
We would, no, that'd be a separate action, but we would definitely support clarifying our definition for retail to include that service component.
Understood. Thank you.
Does anybody else have any questions for staff? Is there anybody willing to make a motion?
I think my opinion is that we include it, but I think we should make a change so that way you're not doing a lot of work for a service industry, that there is a consumer end use, to make it just the same across the board. Because I would hate for it to just be one-offs all the time if we're gonna consider service as part of that.
Did you say that our current definition includes the word commodity? It doesn't say
I'll read it again.
services and so on.
Yeah, to solve any product or merchandise.
Merchandise. If, and I'm maybe presuming a little bit, but if the considered motion would be that this is by right, it is not non-retail commercial, you might include in there that, and that includes the board's interpretation that that definition includes medical services. Even though we still need to change the ordinance, it needs to have the proper language in it, but that would get the interpretation on the board. They could then rely on that as they go forward.
Should it be services rather than specifically medical services?
I would think so.
Well, I think so. I really think so too. I was just being maybe too specific to this one, but no, sir, I agree with you.
Or potentially professional services. If you
Well, it's not just professional services.
Could be a body shop.
Not that I'm saying anything about your institution.
Could be a body shop. What would happen to the one that was forced, that was already in a conditional use permit?
So they have conditions of approval. As long as they're meeting those conditions of approval, they're good to go. If for some reason we would receive a complaint associated with those conditions of approval, that would then, as a conditional use permit, would end up back in front of this board if enforcement action was taken. You being the board that just said that that meets the definition would likely find that those additional conditions weren't necessary.
Or that it predated that interpretation and enforce it.
Yeah, you would get discretion.
Yeah, plus, a development plan for this one would cover much of those conditions that might have gone on a conditional use
Yeah.
permit anyway.
Yeah, and maybe this is where I'll look at Mark. Man, we're getting the weeds quick. Or the applicant, with this particular application, is there a plan for new buildings, or is it just moving into an existing building?
Existing.
Yeah, so it'd be very likely that there's no further development permit required.
Okay, good.
My only concern with just adding services is what if there are other services that later come up that shouldn't be?
Well, that also is why, staff needs to go ahead and work on the definition anyway.
Right. Because on this particular case, I feel like it should be considered, but I don't know where you draw the line.
Yeah. So,
As in regards to this applicant.
Mark, you want to come up here?
In regards to this application, some issues we looked at was parking, and being the way the site was developed as a larger commercial area, with sort of an agreement for cross the area parking, utility easements and such, that they currently have adequate parking to meet the requirements for the scale at which they're proposing to operate. and the only thing that would be lacking in that regard, which is handicap parking. So at the adjacent store, there is handicap parking directly in front of that, in front of the Bariatric Institute. In front of this one, there are currently no handicap parking, so that would be the only suggestion. I think that's something they had intended to do anyway in regards to their development of the site.
They'd be required to provide all of that regardless of new development plan. I mean, isn't that required, period? If you're in business, you've got to provide handicap parking and things of that sort?
It is. Yeah.
It may not be as clear and all of that, but that's still a requirement.
Yes.
They'd get an enforcement letter from you if they didn't do that.
Well,
maybe from
From
somebody.
Holden.
Maybe from somebody.
And so again, just for the board's, totality of information on this, the zone is B2. There are a number of permitted uses by right. And so I'm going to read this list and then you think of other service-related industries that might be covered. So motels, which would include motels, hotels, restaurants and cafes, retail stores, especially those which require large storage or display spaces, motor vehicle service stations or other auto-related establishments, and then planned development projects for commercial use and adult-oriented uses. And so those are all allowed by right already. And so the body shop or, again, like automotive, repair facility, those are already allowed by right in the B2 zone.
Okay.
Any further discussion? We still don't have a motion. Would anybody
I'll
like?
make a motion for us to include services. Is that what I need to? And then,
Yeah, I'll just tell you what I've got so far, if this is what you have in mind. The board determines that this use to be retail, commercial, and not needed, and does not need a conditional use permit. And I can add in the word medical to kind of narrow it, what you're doing here, until we think about these things further, but otherwise, I mean, I think retail is services too, so
Sure.
I'm not sure that's really needed.
that's my motion. So don't to restate it.
I'm sorry, who seconded? Frank?
Frank.
All in favor, say aye.
Aye.
Any opposed? Motion passed. We're going to move on to the other, thank you all, by the way. We're going to move on to the other new application since we started with them first.
Or the old one, maybe. Is that first?
Well, it was just going to go ahead with the new one, the
Oh.
22, 'cause since they started that one.
Oh, okay, all right.
I guess, you're right, they didn't switch it.
Thank you. All right. Good evening. My name is Mark Carper. I'm very pleased to present this application presented by Janet Morgan. This is for a variance for the front yard setback and the rear yard setback for this particular property located at 401 Eli Avenue. The property itself is zoned R2, medium-density residential. It's excuse me, it's 0.193 acres or 8,408 square feet. If you would mind. This is an aerial showing the site itself. What it doesn't show is the topography of this particular site. I do want to note on the left side of where the site is, or on the west side, there's a steep embankment, which would be the rear of the property. On the front side or the left side of this, where you see that little car, that house built, that is also a steep slope. So the driveway area is a ramp that goes up to what appears to be like a little platform. So that's where the house is proposed to be, if you wouldn't mind. This shows the particular zoning and the surrounding zones as well. If you would. These are some plats derived from the property from 2022. And in 1993, you can see that plat, there had been a pre-existing home there. The home was set all the way to the rear of the property, so there's no space between that and the property line itself, if you would. This is what the owner of the property is proposing. I've oriented so it meets the same north-south orientation as the previous maps. The home itself is 900 square feet. It's proposed to be, I think, 30 feet, let's see here, wide and about 46 feet long, sorry, 20 feet wide and 46 feet long. The proposed setback from the front and the rear yard would put the structure 10 feet from the front yard And when I say the front yard, you can see it has a little jig-jag shape here. So each of these squares represents 5 feet. So it'd be 10 feet from this portion of the front property line and 10 feet from the rear property line. The house itself is going to have 2 porches on either end. And the side yard setback is only 7.5 feet, so they clearly meet that requirement. So they are asking for a variance to make use of this property. Again, 20 feet from the front yard and 15 feet from the rear yard, placing the structure 10 feet from each front and rear property line itself, if you would. So in regards to variance, these are requirements that for any variance is granted, the board must find that the granting of the variance will not adversely affect the public health, safety, or welfare, will not alter the essential character of the general vicinity, will not cause a hazard or nuisance to the public, and will not allow an unreasonable circumvention of the requirements of zoning regulations. In making these findings, the board shall consider whether the requested variance arises from special circumstances which do not generally apply to land in the vicinity or in the same zone. The strict application of the provisions of the regulation would deprive the applicant of the reasonable use of the land or would create an unnecessary hardship on the applicant, and the circumstances as a result of actions of the applicant taken subsequent to the adoption of zoning regulation from which relief is sought. It is upon the applicant to justify these areas for that variance. So she has provided evidence, which we're presenting here, if you would please. Our findings on this is that the project site, as I mentioned before, zone R2. The front and rear yard setbacks in R2 zone are 30 feet and 25 feet respectively for front and rear. Proposed dwellings to be 10 feet from the rear and 10 feet from the front, the property lines. The property, as you may have noted, is irregularly shaped. It's not your typical rectangle, and it leaves limited space and area for development. This irregularity is not of the applicant's making. Thus, the strict application of the provision of the regulations would deprive the applicant of reasonable use of the land and would create unnecessary hardship. The applicant is requesting, again, the 20 feet from the front, 15 from the rear for the variance, and the proposed action we assert would not adversely impact public health, safety, or welfare, and would not alter the essential character of the neighborhood, nor cause a hazard or nuisance. If you would, please. Therefore, we're recommending approval of this proposed variance with the following conditions. That property is subject to all regulations of Georgetown-Scott County zoning ordinance and subdivision development regulations. The applicant shall comply with all requirements of other federal, state, and local regulatory entities. The applicant shall provide copies to the Board of Adjustments of all permits issued on behalf of the applicant as a result of this approval, including, but not limited to, business-related certifications, licenses, regulatory permits, and any recertification required. The applicant shall obtain a building permit from the building inspection officer prior to any construction. The applicant shall return the board prior to any change in the proof conditions. Thank you very much. The applicant isn't here tonight, but I'm available for questions if you have them.
Does anybody have any questions?
I will make a motion to approve based on staff recommendations.
Yeah.
Second.
All in favor, say aye.
All right, thank you very much.
One little bit of history, we've had to do variances to many lots
Right.
on that street. They were apparently put together without a lot of foresight at all, and then occasionally been sold and divided unofficially, and so we've had to make all kinds
It's
of
like 2
adjustments.
tracks, isn't it?
Yeah, so, no, that's the
Yeah, I
thing.
drove down that street and said, what?
Yeah, that's all the way from the house that's on the street, ones that are back up on the hillside, so, yeah, no, that's very good.
Okay,
Whenever you're ready,
interesting
sir.
evening we're having. Good evening. I've got another variance application here for you, location being 316 North Hamilton Street. They're requesting to be able to add a guest apartment space in their garage on the property. Typically, the zoning ordinance only allows one principal structure / dwelling unit essentially on any given property. There is a pre-existing home, so they are requesting relief from that portion of our ordinance. Again, R2 zone, it's an oversized lot, so to speak, of 1 3/4 acre approximately, near the intersection of North Hamilton and Bourbon. Overall, we are recommending approval. Please, Elise. This is the project site in question. R2 zoning. Some of y'all may be familiar with the property. The applicant is currently in the process of a historic restoration. They were not able to obtain any state funding essentially to save the garage as it were. It's not necessarily part of the original structure here. And so what they're doing is taking the garage down, putting it back, retaining some of the structural elements that were original to the structure. And in doing so, they inquired about being able to put some living space in said garage, at least if you could. Mark has been so gracious to give you all this language, and this language as well. Again, aforementioned that there was a regulation within the ordinance, section 245. Unless a plat has been approved for a PUD, which has not, only one principal building and permitted accessory structure may be erected on any lot of record or conforming lot. Temporary structures allowable during construction only. You're all right, at least, no worries. So again, this lot is oversized as it pertains to the general character of the vicinity. With a maximum allowable density of 12 units per acre in this zone, say if a developer were to come along, buy the property, take this house down, redevelop it for townhomes, et cetera, they could put approximately 20 to 21 dwelling units on it by the maximum allowable density and development plan, et cetera. Or the commission and board could require the applicant, in order to accomplish their goals, that they have to split the property in half, plat the barn off onto a separate property to allow this second dwelling unit or primary function. Staff has determined that either of these options being required of the applicant would cause undue hardship. Again, somebody could come through by right, take the place down, redevelop it, and it's kind of an unnecessary hardship to make them place their barn on a separate property when this applicant should be allowed full use of the rights of their land. And again, there are some other properties within the general vicinity that have structures that are set up for multifamily use, duplexes, refurbished homes that are now apartment homes, things of that nature. So allowing this type of use would not be uncharacteristic of the neighborhood. Again, project site's oversized. I won't bore y'all with this or beat you over the head with it. Pretty well, we've gone on over all this. But overall, staff finds that allowing this use would not cause a nuisance, safety hazard, be uncharacteristic of the vicinity. If anything, nobody would probably even notice it was there. The intent has been expressed, it's for guests and personal use, not necessarily for a second family or anything of that nature. We do have our 4 standard conditions of approval here listed. However, actually, no, yeah. Ignore that number 3 as a copy-paste error as it pertains to the division of a townhome. So overall, we do have our standard conditions of approval within your packet there. Staff is recommending approval. The applicant is unavailable. I've had extensive conversations with them. I'm sure I can let them know how things go tomorrow, however the board pleases. Okay. Any questions or concerns? Ms. Teague?
Can you back up a second? Something that you said they're doing it for personal use, not a guest room or something like that?
Well, when I say that, it's not like they're going to lease it out to somebody that's not family or a guest or something like that. The intent is not to create an apartment for lease or anything of that nature.
I guess I don't understand why there's a concern about hardship if they really want. I don't understand why they, never mind, it's none of my business what they, yeah.
Well,
Why
we
don't
can
they
talk it
just-
through.
Why don't they do their apartment in the basement? It's an unfinished basement. Why do they have to, if they, never mind, that's
'Cause
their choice.
wet.
That's their choice.
Wet. I can tell you from my old home, that's wet.
Okay, that's their choice, okay.
Does anybody else have any questions?
I'll make a motion to approve based on staff recommendations.
Second.
Ursula.
Ursula, yeah, okay.
All in favor, say aye.
Aye.
Any opposed?
I'm opposed.
One opposed. All right, motion passes. Thanks.
The end?
Does anybody else from the board have any questions for staff?
Is this their new intern down at the end?
So this is Mr. Noah Smith right here. He is finishing up his senior year at Georgetown College. He has already accepted a job offer from our office.
Yeah.
So he's currently working part-time. As soon as he's done getting that schooling out of the way, he'll start on board full-time. Nice to meet you all.
It's nice to meet you.
All right, thank you.
Yep, sure.
One of the I guess one of the things we were going to talk about tonight was postponed to December. So if there's no other questions for staff, do you all have anything else that you need to discuss? Then the meeting's adjourned. Thank you.